Right from the start, pay attention to this detail. The suspect allegedly ordered the victim into the front seat, a common tactic predators use to isolate control. Legally, her refusal becomes crucial to establishing non-consent and escalating risk. Remember that as the case unfolds.
All right, the court is calling 2024 CR 3774, State versus Luis Alberto Deleon. Can I have parties announced for the record for the state? Defense?
Jason Wolf for defense.
And are you Mr. Deleon Jr.?
Yes, ma'am.
You entered a plea of no contest to indecency assault on February 25th, 2025. According to your plea bargain agreement, the state is recommending deferred adjudication. And at the last hearing, state you informed the court that you had spoken to the complainant.
Yes.
And the complainant has no objections to this agreement.
Correct.
All right. Is there anything you wish to say on behalf of your client?
No, Judge, we would just ask that you kindly follow the agreement. He's taking responsibility, and we just want to put this behind it.
All right. And is there any reason why I should not consider jail time as a condition?
Judge, this was a fact pattern that both the defense and the state have gone back and forth on, quite frankly, during the plea bargain process. I know reading initially the police report as it's presented to the court.
Notice what the judge is doing here. She's questioning why jail time shouldn't be part of the sentence. Judges don't typically challenge plea agreements unless something in the police report raises serious red flags. What do you think she saw?
Has been reduced to an agreement of the parties. It is a Class A through agreement and negotiation because of that fact pattern. We're here saying that this result is good for our client. He would like to take this result. We just kindly ask that you follow that agreement. Assessing jail time, I think, would not be appropriate in this instance. And that's what we're asking. We just ask that you
Why
follow
wouldn't it be appropriate? That's what I'm trying to get to the crux, because I read the fact pattern, the police report, and I'm trying to figure out why I shouldn't give him jail time as a condition. State, any response to that?
Sure. After speaking with the complainant and gathering more information, I think that this is more in line with what the state is able to prove, Judge, and probably more in line with what is appropriate in this case, Judge, as opposed to what it was indicted as. And we've explained that to our complainant, and she fully understands that that's where we are.
So you don't think jail time as a condition would be appropriate in this case?
Don't, Judge.
All right. Are you employed?
No.
What do you do?
I just graduated for ADC security.
From what? For what?
ADC security.
All right. Does everybody think this is appropriate for him to be district manager of security, and he's just agreed to do a permanent surrender of his TCO license?
I don't have any information about his current employment, Judge, or any opinion on his current employment.
All right. So can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. You can lower your hand, state your name for the record.
Luis Deleon.
All right. What specifically do you do?
I just train register service, door-to-door sales.
All right. Do you go into anyone's homes? Do you go door-to-door sales?
I just train. I train and run office meetings, make sure all the back office stuff taken care of.
All right. This is what the court is going to order with regards to this occupation. If he is entering anyone's homes, knocking on any doors, he needs to let them know what his charges are, if that's what he's going to do.
May I address a couple of things?
Sure.
I'm hopeful that we're no longer considering jail time as a condition. I think he's granted deferred. I think jail time as a condition is a punishment that he certainly didn't anticipate, and I would hope that would not be something that would be somewhat busting our plea bargain.
Well, I don't think that's a busting of the plea bargain. I'm going to follow your agreement for him to have deferred.
This is where the tension spikes. The judge isn't just rubber stamping the deal, she's drilling into his job duties to determine whether he poses a risk to the public. Imagine being in that courtroom. Do you think the restrictions she's considering are fair or too lenient?
But if he is going to be employed, because it seems like he's given up his TCO license, but yet he's sort of still engaging in an occupation that's security. What I'm saying is, if he is not allowed to go into other people's homes as a director unless he lets the person's home that he knows that he is entering, that he's on deferred for this. That's what I'm saying. He's not allowed to go into people's homes. You understand that, right?
Homes everywhere across this world. He's not allowed to go in there unless
Yeah,
he expresses the conditions of this plea bargain.
If
That's
it's,
my
if it's,
understanding.
no, what I'm saying, you,
Even if
if
he's
it's,
giving consent to enter
if
that
it's,
home.
if it is a part of his occupation, no, he's not allowed to.
During the course of his.
Okay, I misunderstood, Judge.
Okay. All right, so do you understand that? So if you, as a part of your occupation, go into someone's home and they're not aware of these charges and the courts finds out about it, there's going to be a motion to revoke filed. Do you understand? And you understand the reason why the court is requesting that? All right. Do you have any children?
No.
What are their ages?
Daughter's 13 and my son's 10.
All right. So the court is going to sentence you to 2 years deferred adjudication, $1,000 fine. That'll be probated. MRT, the AIDS awareness course. There's to be a permanent surrender of your TCO license. And it also says ID here. There's to be no contact with the complainant. There's to be no entry into any homes as a part of your occupation without notification of this charge to the home's occupant and your employer.
Do you want written acknowledgement or
Yes.
just verbal acknowledgement?
Written acknowledgement. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors.
Quick recap: deferred adjudication, fines, parenting classes, community service, home entry restrictions, and mandatory notifications. This isn't a light slap on the wrist, it's a heavily supervised probation. But the big question is, will he follow it?
Field visits 1 time per month for 3 months. 180 hours of community service restitution. I'm going to require parenting classes. Once you completed parenting classes, your community service hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court in order to be successful on this probation?
No, Your Honor.
All right, did you review the document entitled Child Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. You're welcome.
Thank you, Judge.
You're welcome.
All the chairs are here.
All right, just give me 2024 CR 3774 State versus Luis De Leon. All right, you are here. Oh, thank you. You're here requesting that a bond be set. Is that correct, defense?
That is correct, Your Honor.
All right, and it's the court's understanding that you all have reached an agreement?
We have.
Judge, perhaps not to conditions.
All right. Any witnesses with regards to conditions for the court to set?
Yes, Your Honor, we would call Mr. De Leon.
All right, Mr. De Leon, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Louis De Leon.
All right, defense, you may proceed.
Mr. De Leon, the court is presently considering whether to grant you a bond on this motion to revoke, what that bond should be set at, but she also needs to know if there's any special conditions that need to be imposed as a condition of your bond. I'm going to ask you about a couple things in particular. First, I want to start with any history of mental illness that you might have. Do you have, or have you had in the past, a diagnosis for any mental illness or disease?
No, sir.
Are you receiving, or have you received in the past any treatment or therapy for mental health issues?
No, sir.
Okay, I want to ask you also about substance and alcohol issues that you might have. Have you ever received any treatment or counseling, whether court ordered or voluntary, for any substance abuse or alcohol abuse issues?
No, sir.
Okay, thank you, Judge. I'll pass the witness.
Any questions?
And if I may just talk about procedurally, the new case, Judge, not the substance of the new case.
Yes, can you tell me, the name of the complainant?
In the new case, Judge,
Yes.
it is Ms. Natalia Aguilar. Mr. DeLeon, did you get picked up in a pawn set August of 25 this year for the Misuse assault case?
Now we're shifting into the bond revocation issue. When a defendant misses court dates or gets rearrested, judges become far less forgiving. The defense is trying to frame everything as a misunderstanding, but missed appearances often sink a defendant fast.
Yeah. Yes.
You get arrested
Yes.
in August.
Yes.
They set a bond.
Yes.
And then was that bond forfeited?
I'm not sure, honestly. I believe last I heard it was like 4,000.
Did you get rearrested in that case?
It's in August.
Yes.
I turned myself in for the MTR.
You turned yourself in for the MTR.
Yes.
Were you aware that there was a failure to appear in September?
No. When I talked to my probation officer, it was August 27th, I believe, and she said that she was gonna, I guess, I don't know what it's called, but essentially she was gonna, so that there was no violation, she was gonna essentially, I don't know, waive it or something like that. And then once I turned myself in, everything would sort itself out.
Or they set that bond in September before?
I'm not sure, sir.
No additional questions, Jeff.
All right. So do y'all anticipate this being a contested hearing?
I'm sure.
Well, Your Honor, I guess you've looked at the MTR at this point. There's a new number one that would be contested. The number two allegation, I need to confer with my client, but I don't know that that would be as contestable. So I am
All right.
that's
Ms.
the best
Ferguson?
I can tell the court today.
All right, this is going to be set for a contested hearing. So your contested hearing is going to be December 11th. You need to be here. If you're not released, you will be brought over from the jail. Then the court will follow your agreement. The court will set your bond at $75,000. As I said before, there's to be no contact with the complainant and the allegation of the new number one. And of course, there's continued no contact with the complainant for the instant case. Do you understand? All right. So parties, if this is going to be contested, you all need to be prepared for a contested hearing on December 11th.
Yes, ma'am. Judge, the state further was asking for GPS, but that part was not heard.
All right. Mr. Valentine, the state is asking for GPS. You're opposed?
We oppose that, Your Honor. We don't believe it's a necessary condition in this case.
All right. This is what the court will do. There's a $75,000 bond, which is agreed to by both parties. There's to be no contact with the complainant in the instant case or in the allegation of the new number one. There's to be partial GPS, waive fees, and that is for attorney consultations. Is there anything else?
I think from the state judge.
So,
Judge, may I ask that that partial be extended to any employment provided, proof of employment is provided to the tracking provider? Or
once there is employment that has been obtained, then the court will consider that at that time.
Thank you, Judge.
All right. So what that means is you're allowed to go speak with your attorneys. That is it. So if you drive to your attorney's office and you see an HEB and you're like, I should stop at the HEB, you're not allowed to do that. You must leave from wherever you're stationed with your GPS. If it's at your home and you have an appointment with your attorneys, pretrial services is going to want to know of that appointment. And then you are to leave there without making stops to meet with your attorneys. Do you understand? Is there anything that you do not understand about the court's orders? So you'll be back on December 11th. That will be for a contested hearing. Both parties will be prepared to proceed at that day. All right. Is there anything else from the state or the defense?
I think from the state. Yeah.
And here comes the hammer: GPS monitoring, no-stop travel rules, and a $75,000 bond. The judge is clearly sending a message about accountability. If you were the judge, would you have added more conditions or do you think this is enough?